I hinted to this in our headlines, and the Senzo Meyiwa murder trial does continue today. Back on the stand for cross-examination is Meyiwa's childhood best friend, Silindelo Masikane. Well, the defense in the case has accused Masikane of being evasive in his answers. But another interesting development in the story is that a lawyer representing Meyiwa's then-girlfriend, Khumalo, has been denied access to court documents. eNCA Silindelo Masikane has been covering the story for us and joins us now for more updates. Slee, always a pleasure having you back. I mean, what's the very latest surrounding this case?
Well, of course, we have resumed with the November sitting of the Senzo Meyiwa murder trial, beginning yesterday. And of course, back in the witness box is Silindelo Masikane, who's the state's third witness. And you remember that we began this trial back in April. So moving at a snail's pace, but of course, more to unpack in terms of court proceedings. And I am joined by legal expert, Mr. Zola Majavu, this morning. Thank you so much for your time. Let's just unpack and start with that denial for Magdalene Munsami, Khumalo's lawyer, to be allowed back into court. A lot of criticism coming not only from the judge, but from counsel themselves in terms of her request to have access to court documents and transcripts. Did Ms. Munsami perhaps overplay her hand at this point?
Good morning, Slee, and good morning to the viewers out there. The short answer is, with respect, I believe she did, because her client is not entitled to those documents. From what I gathered from the state, she is one of the state witnesses. And that being the case, she does not need a watching brief performed or undertaken on her behalf by any lawyer. Secondly, she's not entitled to the contents of the docket, nor is she entitled to the transcript. She is a witness like any other witness, and I do believe that she went slightly beyond. I can understand maybe those were her instructions, but it's instructions that she perhaps should have dealt with differently. I think the judge and opposing counsel was correct in expressing their displeasure with that approach.
Let's go on to the cross-examination, Mr. Majavu. Several times we saw Judge Chifua Maumela cautioning the witness, Silindelo Masikane, to answer the questions, to not answer questions with questions. What inferences does the court perhaps make from a witness that seemingly does not answer questions directly?
The court, remember, at the end of the day, it has to make a credibility finding against the performance and testimony of a witness. And this is precisely why in such cases, the court must observe the deportment and the demeanor of a witness. The inference that the court may draw is that this particular witness is not credible, is evasive, and the weight that the court may attach to his testimony will be significantly reduced simply on account of his evasiveness. Even to answer very simple questions, he does come across as a bit argumentative and a tinge of arrogance, in my view. So I don't think it's a good performance for him. He's definitely going to do the state's case serious harm, because the weight that may be attached to his testimony is seriously going to be eroded by this type of conduct. You don't answer questions with questions when you're under cross-examination. You answer to the best of your ability, short and sweet. If there's a need to amplify, you can do so, but you cannot be evasive at all. It's not a good showing.
Maybe then let's get into some of the line of questioning from Titi Tobane for accused 124. He's drilling in on the inconsistencies between Masikale's statements and his testimony in court, but also trying to discredit the doc identification. Is Tobane correct perhaps in trying to show the court that Masikale's doc identification cannot really be relied upon in terms of pointing out accused number 2?
In fairness to my colleague, Mr. Tobane, I think he's on to a good point. He has to discredit that type of identification, because so far that's about the only link towards his client. And if he can get that identification thrown out of the window, then there's very little so far that the state would have advanced against his client. So I think he's doing very well. He's on to a very good point. I would have been surprised if he hadn't drilled down on that very important aspect. How far he'll be able to go with that, it remains to be seen. But if you ask me now, at this early stage of the proceedings, I think he's doing fairly well.
Maybe then lastly, Mr. Majavu, we are expecting Advocate Zandile Mshololo for accused number 5 to also begin her cross-examination perhaps sometime today. And her client in particular has not been accused as being one of those who was inside the house. Perhaps what kind of line of questioning can we expect from her in terms of discrediting Dumelo Madlala in the witness box?
My sense would be if Dumelo Madlala has not in any way implicated or sought to implicate his client, she should just leave it. You don't cross-examine for the sake of cross-examining. But she is a colleague, very experienced. I am not sure what her angle would have been. But personally, if a witness has not implicated my client, I would be better advised to just stay out of it.
And then perhaps moving forward then, Mr. Majavu, we are sitting for 3 weeks. And, a lot of legal experts telling me that it simply won't suffice, perhaps in terms of wrapping up the state's case. What are your thoughts?
Not by a long shot. We are nowhere next to having gone through the quarter of the distance that is yet to be covered. But at least I can appreciate that everybody involved is now doing the best they can. We lost a bit of time yesterday with the request by my colleague, Ms. Monsami, which ought not to have really been entertained as much. But these are the type of side issues that sometimes potentially squander what would otherwise have been useful court time. But it remains to be seen. This type of proceedings do take long. But at the end of the day, the speed with which everybody moves along would be informed and dictated to by the accuracy of the evidence in chief, as well as the pointedness of the cross-examination, and less side applications that do not take the matter any further. But yes, 3 weeks is hardly enough, but at least significant progress would be made this time around. And I'm sure we are going to need another 3 sets of 3 weeks if the state's list is anything to go by from a witness point of view.